Um, so welcome everyone, and we're excited today to talk about legal planning issues in assisted reproductive technology. This is a field that is quickly emerging. I think the number of children who have been conceived using some form of ART has tripled in the last 15 years and just continues to grow. It's also an area where the law has not really kept up. So it's a bit of a wild, wild west out there in terms of legal rights and procedures and what's required. So here today to talk with us about kind of best practices and what we can do to kind of protect kids and protect your parental rights. We have Sarah Hechtman. Sarah, you want to introduce yourself?
So hi, I'm Sarah Hechtman. I'm a family lawyer at Rower LLC here in Manhattan. And I have been expanding my practice to include representing mostly, as it turns out, intended parents in the process of getting to parenthood through the use of assisted reproductive technologies. Although, of course, there are people who represent donors and represent surrogates, and we can talk a little bit about those processes today.
Great. I'm looking forward to it. So, in this area, I feel like it is kind of quickly evolving. And a lot of my clients, they come to me, they may have concerns about, I mean, one of the concerns is that if children who are conceived through any kind of donor material, whether the parents would have the right to, or if the biological parent or donor or whoever may have any right to intervene if the parents passed away, and what do they need to do to make sure that happens, and that instead that their kids will go to their intended guardians who they've designated in their wills. Do you have any thoughts on that? Like, do they need to do anything to kind of protect themselves or establish their parental rights?
So, the history here is that New York has only recently signed into law the Child Parent Security Act. It was passed in 2020 and it was made effective in early 2021. So it's brand new. And it sort of brought New York into the modern age when it comes to family creation. So up until this new law existed, what I would say is a second parent, if that's the issue, if you have like a child born to a particular parent and there's a second parent, so a non-traditional family, a gay couple or something like that, then that second parent would really need to do a second parent adoption in order to protect their parental rights. And that can still be used. That can still be the method that a parent could use. The issues with the adoption process is that it subjects families to home visits and social worker interviews and all kinds of fairly intrusive things that really ought to be unnecessary when you're the intended parent to a child. So to get back to is there any risk of a donor sort of stepping in? I think the answer to that is no, so long as the donation itself is contracted for and well documented, and so long as the intended parents have the legal orders that they require in order to be acknowledged by law as the parents. But if I might, a little bit about the Child Parent Security Act, because it is really sort of state of the art for where the world is legally with regard to assisted reproductive technology. And what it does is it's specifically geared at legalizing surrogacy, and meaning that you can use a surrogate mother in the state of New York now, which you couldn't up until 2021. But as part of the legislation, it provides a process by which the intended parents become legally the parents of the child born of ART, and the donor waives all of those rights. And so while it was while it's sort of earth-shattering for New York in that it legalizes surrogacy, it also does a number of other things that enable couples who are using donated gametes. It enables them to get that legal judgment of parentage even before the child is born.
Okay, so so before they really had to go through this second parent adoption, even if, and I had clients even, they said, oh, well, my name is on the birth certificate, that really wasn't even enough, that you had to go through this process, which was pretty intrusive.
Yes. And so, I mean, I think that, the legalization of gay marriage obviously solved some of these problems because there are presumptions in the law about the child of a married couple belonging to that couple. But nevertheless, yeah, I mean, in terms of couples where there's no official civil union or marriage, I think in particular for those people, it was an issue that now can be avoided.
Okay, great. Yeah, and I think that specifically in the previous law, up until this recent change, it referred to the paternity of the child, that there was a presumption of paternity, but not for a same-sex female couple. And so there was really kind of this, if you were a married couple and you used any kind of surrogacy or arrangement, then the father would be, they presume they would automatically have those rights. But if you were a same-sex couple, that wouldn't really be the case. So yeah, so I'm glad that this was able to kind of move us forward and helping to equalize that situation in terms of kind of gay rights and rights overall for parents. Um, okay, so, and you mentioned that New York just legalized surrogacy, and I think a lot of people don't realize that surrogacy was not legal in New York up until, when was it, last year? Is that right?
Up until 2021. So
Okay, 2 years ago.
so
A
we
year
can
ago.
talk about compassionate surrogacy, which is when you either a friend or a family member carries a child for someone else, right, for free without compensation. That there really is. There's never. I don't really think anyone's ever had an issue with that. So if I'm infertile and my sister generously offers to carry a baby for me, no one can object to that. It's the paid surrogacy situation that was, perhaps still is considered somewhat controversial, right? Because it's you're selling your uterus and using your uterus to carry somebody else's baby. My experience in having seen the results of those arrangements is that actually the surrogates themselves will talk about how it was, one of the most meaningful things that they have ever done for somebody else. I mean, it really is even if it's paid, it is an act of tremendous sacrifice to do that for someone else. So I think it is wonderful that New York has now acknowledged that it can be legal, and in fact has put in place a statute that is very respectful of surrogates and has a surrogates bill of rights that provides for all of the things that need to be provided for that woman, right? Health insurance and life insurance and covering of legal costs and travel expenses and things like that. So the statute itself is actually pretty comprehensive and very protective
Great.
of the
Well, I'm
women.
so glad that we finally moved in that direction, because I know previously couples would had to go to New Jersey or other states to get their surrogates, and which seemed like unnecessary when we could just do it right here in New York. So another issue, so sometimes I have clients that will ask about embryos that they've created, and what happens if they passed away, who would get those embryos, or if one of them passed away. Do we have any laws? As my understanding is that there's not really any law in this area, and that it goes to it's kind of your contractual agreement that you have with the fertility clinic that is storing these frozen embryos?
So yes, it's my experience that the clinics who are handling the frozen genetic material, whether it's gametes or embryos, is very thorough in terms of having the the parties sign off on whatever they want to have done in terms of a disposition. So the fertility agency that you're working with ought to have a contract that is explicit about all of those things, like what happens if one of you dies, what happens upon divorce. All of those sorts of things ought to be handled in a contract. And then it's also my experience that, you know, you're going to have if you're using a donor, there's a contract with a donor. If you're using an agency, either to obtain donor gametes or to find you a surrogate, the agency is going to have an agreement that you need to sign. So there's going to be various contracts along the way. And your intent should be made explicit, you know, in each of those places. And we hope they're not inconsistent. I actually don't know what would happen if those agreements were inconsistent, but my assumption is that whatever the sort of the least invasive, right? You can't compel the release of an embryo if one of the parties who created that embryo doesn't consent, for instance. That I know to be true. So you would need to, if you were looking to get that embryo, you would need to show beyond any shadow of a doubt through a contract that the other party intended for you to have that embryo.
Okay. Um, so these are things, and I feel like when you're going through this process, it's easy to just sign these documents pretty quickly and not really think about where, these have tremendous consequences for both parties, and kind of what ends up happening in the future, where the situation might not be the same as it is when they went into this. And so, I mean, do you recommend that people hire a lawyer when they go through this process, or is this something they can navigate on their own?
I don't think anyone should be navigating working with a donor, working with a surrogacy agency on their own. I mean, I've seen firsthand the problems that can arise when someone doesn't really understand what it is that they're um, signing off on. I mean, usually, actually, it has to do with money. In my experience, it's that you know, the intended parents didn't understand what all of the costs were going to be with regard to a donor. Um, you know, which in the greater scheme of things is a relatively minor issue. But nevertheless, it's really important that the intended parents have a lawyer, a donor should have a lawyer, the surrogate should have a lawyer, and obviously the agencies that place or match, you know, donors and surrogates with intended parents, they have a lawyer as well. Often they're just somebody in-house who, you know, works for the agency all the time. So yes, counsel is very important in
Okay,
reviewing these documents.
great. Yeah, and I think even if there is no donor, but you're just creating, you're having like frozen embryos, that I'm not sure if you need a lawyer necessarily, but you want to make sure that you're really thorough and in terms of going through those contracts, and what you're agreeing to, what are
Right. I
you
mean,
looking at.
right. I think like that's so sort of been like the standard, um, you know, you're using an IVF clinic, you know, to store your frozen embryos. When that clinic shows you the contract, you need to make sure that you're asking all of the questions that you have. And if you want it reviewed by counsel, of course you could. My guess is that most people in that situation would not hire counsel, um, because it's not like the terms of these contracts are impenetrable, right? They're pretty common sense. Like what happens upon death, upon divorce? Do you want to donate unused material to a particular place, or do you want that material destroyed? I mean, they're concepts that anybody can understand, but they have significant impact on what happens later on. So you just want to make sure that you're asking all of your questions and you're not rushing through that process of making your selections and signing off with the agency.
Yeah, and I think that kind of thinking about if you were incapacitated or if you passed away, like really what would your wishes be? And at that point, if you were doing this and you didn't have any kids, maybe you would think one thing, but maybe later on you have kids, and then this would add another child after you've passed. Would you want to do that? And also, then for inheritance purposes, that's another beneficiary. So that's another heir, meaning that your kids that you had are going to get a lesser share than they would have. And so those are issues that can come into play, and you kind of want to think about really carefully as to what your wishes would be. And I will add that New York, somewhat recently, maybe within the last 5 years or so, they added a statute about inheritance by a posthumously conceived child and what their rights are. Previously, they didn't really have any inheritance rights. So, because according to the law, your children were the children who either were in existence at the time or were in utero. And so if the child then was either, kind of came into existence after that, using like frozen embryo or frozen sperm or eggs, then they were just excluded from the estate. And this kind of caused a lot of issues. So in order to address that, there's a provision, a bill that the legislature passed that allows for a posthumously conceived child to qualify as an heir under the law, as a child of the deceased parent under the law. But there are a bunch of requirements. One is that there has to be a stated consent by the deceased parent that this is what they intended, that they intended for, that they wanted, it was their wishes to have a child after they've passed. And or and also to provide, so once the person has passed away, there are all of these procedures that have to take place. So the spouse or the life partner would need to notify the court that they intend to use and to create a child, and it has to be within a certain amount of time. So if the child hasn't been born within, it's about almost 3 years, then they don't inherit at all.
But
So
as you were talking about that, I was thinking that's fascinating. Is there a time limit on that? But the answer is yes, there is a time limit. So
yeah, because they have to distribute the estate, right? So they can't just wait around. And then if the child comes into being later, then all of the money is gone. And so yeah, so then in that case, then the child just doesn't benefit from the estate. They can still come into being, but they wouldn't have any rights under the estate. So yeah, so a very, very interesting. And also, if you have frozen sperm or frozen eggs, you also want to look at those. Often you don't have a lawyer when you're doing this. So say you're single and you want to freeze your genetic material, that you want to make sure that you understand what happens to that material when you pass away. And generally, there will be some provision in there. And you can, in some cases, I think it really depends on the clinic, you can leave it to your estate, apparently. And again, there's not really any law in this matter. It's sort of the Wild West, but as much as we can gather from kind of what's been recommended and what there have been some issues that have come up legally, that you have to have a specific statement of what your intent is in order for someone to be able to use that. So if you wanted, if you had frozen eggs and you had a life partner or a spouse and you want them to be able to use that, then you have to have, after your death, or if you were incapacitated, then you have to have a specific statement on that. And you want that to, probably that would be in your clinic agreement. But it's something you want to think about every once in a while, because when you do it, you might be different than 5 years from that time. So those are things that kind of you want to revisit and make sure that any statements are consistent. So
Right. So would that have to be in your will as well? I mean, I assume, that with a fertility agency, they would, or like a clinic that's hanging on to your material and cryopreserving it. I'm sure there's standard form language in there about what happens upon your death, your disability. But would your will have to be consistent with that if you were actually trying to leave it to someone to use?
yeah, I think that if there was any evidence that your intentions were to the contrary, then that would be taken into account. But I think there have been cases where the executor then took the material, like the parents of the deceased person, they wanted a grandchild, and I think there was a case where they hired a surrogate, and the surrogate miscarried, so this issue never actually ended up kind of coming. This child didn't have any parents, so they even though I think that whatever family member they wanted the child, they weren't presuming to serve as the parents. So you could have this like wild situation where you have a child coming into being, that somebody creates, but without any actual parents, legal parents. So it's really a little bit crazy right now as to what actually happens. And then we have issues as to what are the responsibilities of the executor, or they have to keep those that material frozen, who gets it. So there are, it has to be divided, like, like there's so many, like you can't really put a value on that. So, it's really, there's a lot of issues and a lot of questions that remain unanswered, and I think are probably, hopefully, that the state and the legislature will put some, kind of guidelines. There is a task force that they did provide some guidelines, but there's been no law. So we don't really have a law right now. It's just being done case by case.
So presumably, yes, at some point, if there's some issue that becomes worthy of legislation, someone will propose some kind of a law. But of course, that's not the standard case. I mean, right? We know that the mostly who this new law is going to serve are non-traditional families, infertile families who need to use a surrogate, who need to use donor gametes, and it really does move the law to a place where it's more consistent with what's actually happening with regard to individual families planning for becoming parents.
Yeah, I'm really glad that we have definitely moved in the right direction, and I think there's probably more to come, just because these issues keep evolving and different issues. It's such a new area that, the law is just kind of struggling to keep up. So hopefully some of these things will be clarified for us in the future. So before we wrap up, Sarah, is there anything that you would like to add?
I don't think so. Are there any questions from anyone who's listening?
Any questions? I think there was a question about, why it took so long for New York to legalize surrogacy.
And I mean, I don't know that I'm the right person to really thoroughly answer that question, but I do know that there was a good deal of sort of political activism around surrogacy not being legal because it was somehow like a violation of a fundamental right of women. That there's something about the sale of the use of your body for this purpose that struck some as being wrong or inappropriate. So, I mean, that's kind of the history. I think I mentioned to you the other day that I believe that Gloria Steinem was, famous feminist, was very vocal in being anti-surrogacy, at least, 20, 30 years ago. I wonder where she comes out on it today, but I don't know.
Yeah. Yeah, and she's still around. I wonder if she has made any comments on this. That would be kind of interesting to look up. But it's interesting how kind of norms change and how we view these things has really changed. And I think that anybody who I've spoken with who has been involved in the surrogacy process, that the surrogates really find this to be very meaningful and empowering.
Yeah, mostly I think it's just a happy occasion for everybody, for the surrogate who has helped, for the parents who have finally achieved. Because I mean, you can imagine if you've gotten to the point where you're using a surrogate, you've probably, been struggling for some time for whatever reason with how you're going to make a baby. And so it's a happy thing.
Yeah.
We as lawyers, we so often deal with, the dissolution of relationships, the death of someone, right? Fighting over assets, whatever it is. It's really nice that this is a legal issue with nothing but a happy outcome if all goes smoothly.
Yes, it's always great to see creation of families. Well, thank you so much, Sarah. It's been great having you here, and I hope this was helpful for our listeners.
Yes, thanks for having me.
Okay, take care.